G'day and welcome back to another Wimbledon channel video. Going to be looking at collaborative divorce today. This is for family, the option in Legal Studies HSC syllabus, and it's an article by Caitlin Fitzsimmons which is very, very helpful for those who are doing family. There's a couple of reasons for this and I'll go into them as we go through. Let's have a look at the start of it. More separating couples are avoiding the family court by engaging in collaborative divorce, where the professionals work as a team and all parties commit to not go to court. Collaborative divorce started in the United States in the 1980s and came to Australia in 2005, but industry professionals report there has been a surge of interest in the past year. So this surge in interest is the reason why I'm guessing Caitlin is writing this article. And we're going to look at this new, well, not new, but this different, or we call alternative, dispute resolution. And it's an article that's full of some really helpful things in the syllabus, which we'll go through. Gloria Hawke, a family law mediator with the Mediation Collective, said the publicity over the family court merger and awareness of long waiting times for a final hearing were contributing to the shift alongside a general rebalancing of people's personal priorities during the pandemic. Okay, so this makes it quite a contemporary issue that we're able to focus on. It's showing the HSC markers when you're adding this or quoting this article in your essay that you are looking at something really recent. And note, long waiting times for a final hearing and the publicity over the family court merger. So these are all really recent things, and they're talking about divorce. They're talking about evaluating the effectiveness of the law and achieving justice for parties involved in relationship breakdowns. We're also looking at themes and challenges. So the role of the law in encouraging cooperation and resolving conflict in regard to family, and changes to family law as a response of changing values in the community. So we see a general rebalancing of people's personal priorities, and also the role of the law reform in achieving just outcomes for families and society, and the effectiveness. So almost every single dot point this is hitting so far. Okay, a really helpful article. In the last 12 months, instead of people saying, that's a strange process, I don't know if that could really work, we're seeing a lot of the larger law firms training their lawyers and actually participating in the process, Ms. Hawke said. It's getting more respect and the word is slowly getting out there. Family law firms, such as, you can read those yourself, I'm not going to advertise them here on my channel. If they want to pay me, I'm happy to come back and mention them, are among those offering the collaborative divorce model, which means the separating couple is represented by a team, including a lawyer each, a joint mediator or counsellor, and sometimes other neutral professionals such as accountants and valuers. Any legal advice is shared openly, and if the process breaks down, those lawyers cannot represent their clients in court. That's a key part of this process. So basically what it says is, we understand you two don't get along or are divorcing for whatever reason. We're going to work together. You'll have equal representation. You'll have your own lawyer. You'll have professionals who are looking at your house and they'll value all of your assets, etc., etc. And the idea is that we will represent you. If you cannot disagree and you decide to go to court, we have to walk away. So basically it stops this idea of, we'll see you in court, which Caitlin's going to talk about. Family law solicitor Sue Abrams, the Vice President of the Australian Association of Collaborative Professionals, said this created a powerful incentive. There's no ability to pull if you don't like this, I'll see you in court. Everybody's got some skin in the game to try and get this resolved, Ms. Abrams said. More often than not, people don't want to stab each other in the eye. They want a civil resolution, especially when children are involved. Proponents say for most couples, the collaborative process is more likely to lead to a resolution that works for the whole family and preserves relationships. So we're talking about encouraging cooperation and resolving conflict. Reducing stress for the adults and any children. It is not recommended for situations of family violence, addiction, or child abuse. Dealing with domestic violence. You can even add that into this answer. The rise of collaborative divorce is reflective of a general trend towards alternative dispute resolution, which also includes mediation and arbitration. While collaborative divorce, I keep struggling to say that, while collaborative divorce by definition only exists outside the court, the family court is expanding its resources for other types of dispute resolution and has appointed Senior Registrar Anne-Marie Rice to a new role driving that. So there we have another, when we're looking at it, the legal processes involved in dealing with problems in family relationships. So we're looking at divorce, we're looking at the kind of effectiveness of the law, and they're actually trying to expand their resources for other types of so that's arbitration, using magistrates, etc. Over the last several years or decades, there's been a shift, and collaborative practice is reflective of this, to the idea that lawyers should be problem solvers rather than just litigators, Miss Rice said. And there we're looking at changing values in the community. Nearly 50,000 divorces are granted every year, according to the Australian Bureau of Statistics, but many property or parenting arrangements are resolved informally. In February, Parliament passed the controversial merger of the Family Court and Federal Circuit Court with the aim of reducing the backlog of cases. Currently, it takes about 20 months from the time the court action is commenced to a trial in the Family Court, and 16 months in the Federal Circuit Court. That is evaluating the effectiveness of the law in achieving justice for parties involved in relationship breakdowns. 20 months. A 20-month wait from the start to your trial. If you're in the Family Court, remember the Family Court is for more complicated cases, and 16 months. A year and a third for the Federal Circuit Court. Okay, so that's really looking at the problems here, and that's if you're looking at effectiveness, surely the time and the cost is a big thing to talk about from this article. However, over the past 5 years, the Family Court has also overseen a steady rise in the number of consent orders where the parties come to an agreement either independently of the court or with the assistance of the court's resources and have it registered with the court. Okay, so alternative dispute resolution other than going to court. In 2019 and 20, the court granted 14,946 consent orders, and in the same year, it made 2,394 final orders where the outcome was determined by a judge. So we can see a lot more consent orders to final orders. Lawyers say contentious cases can take years to resolve and cost hundreds of thousands of dollars in legal fees. With collaborative cases, Ms. Abrams said collaborative cases typically took 3 or 4 meetings to reach agreement and cost $10,000 to $25,000 each. So there you're looking at the benefits of it, much less time and much less money. Sanya and Vaughn Sardi, hopefully I got that right, from Allambie Heights agreed to separate in July 2019 and used a collaborative process. The couple is now bird's nest parenting, where the children aged 10 and 13 stay in the family home and their parents take turns to stay with them. Wow. Mr. Sadie has bought out his ex-partner's share in the house, while Miss Sardi and her new partner are renting a 2-bedroom flat in Manly, but both parents have their own room in each property. I went through 2 horrible experiences as a child when my father married and divorced twice, and I don't want that for my children, she said. I chose this for everybody's mental health and well-being. I still like Vaughn. He's a very good friend to me, and I don't want to ruin that. Miss Sardi found the collaborative process amazing, but added that it helped that she also had personal therapy, while Mr. Sardi said he and his ex-wife to get along better now than before. But that was also because of their character. Other couples who spoke to the Sun Herald say the collaborative process was still very confronting, but the structure ensured they reached the best outcome possible. Okay, so how could you use this article? Well, if you're asked a question in the HSC, especially if it's a question looking at one of these themes, then you can talk about the changes in society and how the courts are dealing with this. So, for example, the role of the law in encouraging cooperation. You can say that the legal profession are training more people and that the actual court itself is starting to put more resources in to the alternative dispute resolution. Okay, so that was in here somewhere where it was talking about they're starting to do more and putting more resources in here. The Family Court is expanding its resources for other types of dispute resolution and has appointed Senior Registrar Anne-Marie Rice to a new role driving that. And there's a nice little quote from her. Over the last several years or decades, there's been a shift, and collaborative practice is reflective of this, to the idea that lawyers should be problem solvers rather than just litigators, which is very nice for encouraging cooperation. Sorry, really struggling at the moment with this whole reading words business. We've also got changes to family law as a response to changing values in the community. This would be a really good example for that. And you could talk about stats in that. So these stats, 1920, granted nearly 15,000 consent orders as opposed to only, just under 2,400 final orders where the outcome was determined by judges. So that shows you just how many people are working it out outside of court. And you could also talk about the difference in cases versus your collaborative approach there. Also, if you're asked any question about effectiveness and evaluating the effectiveness, you can talk about this concept of the merger. And one of the things, I don't know if you picked up on it, it's basically saying people are turning to here because of the merger, because of publicity over the family court merger and awareness of long waiting times for a final hearing contributing to the shift. In other words, we're seeing not just changing values, but we're seeing the effectiveness of the law or the ineffectiveness of the law. It's not being very ineffectiveness. Wow, sorry guys. The ineffectiveness of the law causing people to turn to alternative dispute resolution because of how long it takes and people not being happy with the merger. You remember that merger basically is the family court. Where have we got the wait times? Down here. The family court is a court for more complicated cases. Your judges are more experienced. Your judges have specialist training in dealing with this, and that's why they take longer. The Federal Circuit Court is dealing with less complicated cases, so they usually take less time. So the government, in their wisdom, decided, you know what? Well, why don't we merge them so that we can kind of reduce the backlog of cases, which of course is not going to happen. What you're going to have is Federal Circuit judges who are less experienced taking some of these family court cases and the outcomes not being as good. So something you can talk about there. Hopefully for you, a really helpful article. Caitlin Fitzsimmons, April 25, Anzac Day, 21. So really, really recent, contemporary. If you're doing family for legal studies, make sure you write that down. Take some quotes, take the stats. Remember it because it could apply to a whole bunch of questions that you may be asked in the HSC.